Chief Judge Gregory, can the courtroom deputy open court?
Yes, please. Thank you.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning.
Morning.
All right, Mr. Brignac, you may proceed.
Thank you, Your Honor. May it please the court, Eric Brignac for Samuel Kerr II. On August 26, 2019, the district court entered a, quote, judgment in a 2255 action, the Joint Appendix 53. That's a final judgment that granted the writ. It ended the case. It gave Mr. Kerr exactly what he asked for. And critical to our purposes, it started the United States 60-day appeal clock. The United States did not appeal, and it cannot here use Rule 60 to try and get around the statutory jurisdictional 60-day appeal requirement.
Mr. Brignac, this is Judge Thacker. Are you saying that it was a final order simply because it gave your client what he asked for? And what about sentencing? Ordinarily, orders aren't final and appealable to this court until there's a sentence.
Thank you, Your Honor. In a criminal case, in a direct criminal case, that is certainly true, that nothing but for some small interlocutory issues, nothing can come up to this court until there's sentencing. This is different because it is a 2255, Your Honor, and it is not a direct criminal case. As this court is well aware, having read the briefs, the core issue here is whether the resentencing that the district court ordered kept this case from becoming final, as it did in Andrews, as it did in all the cases the government cited in its brief. And the reason it did not is because in every one of those cases, except for Martin out of the Ninth Circuit, the resentencing that the district court ordered in all of those cases was a resentencing on at least one of the counts that was the subject of the 2255. And the reason that's critical is because one of the justifications going all the way back to Andrews and cited by all the circuits for saying that the 2255 is not final in those instances is because we want to avoid piecemeal litigation. That makes sense, because if I ask for a remedy on a 2255 count and the district court grants it and says, Mr. Brignac, we're going to resentence you on that count. We're going to give you another capital sentencing hearing, or we're going to give you a resentencing with the Booker understanding we have now. That is not final. It would not be efficient for this court to review that until all of the remedy has been granted. That differs from this case critically because here the district court granted the writ, gave him exactly what he wanted. Nothing the district court could do after that point, after that August 26, 2019 order, could change anything. Nothing the district court could do at the resentencing could have vacated, changed, or altered the final order, the final judgment, giving him what he wanted. He said, please get rid of my 2924.
What if, Mr. Brignac, what if we find that this wasn't a final order, that it was interlocutory? Is there any way for you to prevail then?
Your Honor, I think Your Honor is hinting at possibly we could find the district court's granting of the Rule 60 to be an abuse of discretion. If that's not where you're going, I'm sorry, because you're right. Our argument here is that legally this was final. It was not interlocutory. But what if it were interlocutory for its discretion? And if this panel were to agree with that, we would be happy. I think it would be appropriate to have supplemental briefing and have the government respond. But abuse of discretion is a very tall order. And as I'm reviewing this case, I'm thinking, why does this feel so wrong? Why
Well,
does
if it was interlocutory, wouldn't Rule 54 apply as opposed to Rule 60, as the district court indicated at one point?
and the district court did allude to that, our position, so yes, Your Honor, it would be under a different rule. And the district court made that position is that this is a final order, so Rule 54 would not have been appropriate. The government correctly came in under Rule 60. It's just that Rule 60 did not give it proper relief. And why does
Mr. Brignet, don't we review sentences in the aggregate? And there were 2 counts out there where a sentence had not been imposed at the time.
Yes, so, Your Honor, in general, this court does review on a direct criminal appeal finality and the special circumstance of 2255. These counts were vacated. The sentence was corrected down to 0. They went away. Then, Your Honor, there was a plan, that the government's urging for a separate resentencing on count 1. After that resentencing, either party could have appealed, and that would have been a criminal appeal, and this court has talked about the hybrid nature of 2255. So either party would have had 14 days after the resentencing to appeal that to say it was procedurally or substantively unreasonable. But and I think if Your Honor is hinting, say, at the sentencing package doctrine, that's not applicable here, because that is a doctrine that, say, when this court can send it back to the district court and say, you need to reconsider this as a whole. That's not what happened here. Here, the district court granted Mr. Kerr, and also the government, because the government did not oppose this, the government joined in this, granted the parties exactly what they wanted. Those counts went away, the court granted the writ, and that was it. And the fact that this other count was out there for resentencing superficially makes this seem like Andrews, that to decide what the remedy the court gave, you look at what was asked for. And what was asked for here was vacating those counts. We could have certainly, Your Honors, looked at this as an abuse of discretion case. If you look at what the district court did, it doesn't feel right. But the reason it doesn't feel right is because the district court came in and committed legal error. It upset something that was final. It upset something that it couldn't have changed at the resentencing. And this wouldn't lead, adopting this rule, this sort of, understanding that this case is different than Haddon and different than Andrews, wouldn't lead to the piecemeal litigation that this court and the Supreme Court was worried about. Granted the writ, the government could have appealed it. The resentencing would be an entirely separate appeal, raising entirely separate issues. Critically, unlike the situation in Andrews or Haddon, where the resentencing would be all tied up in the relief that the parties asked for. So that's why this case differs. So then why should we adopt Mr. Kerr's rule? Well, because of the critical interest in finality. When district courts grant 2255 motions, that's a moment. That matters. And to just sort of say, oh, but because of this ancillary resentencing that's hanging out there, we're going to say that that wasn't final. It undercuts the system's interest in finality. I mean, look at this case. It was 100 days later. Mr. Kerr, the government, the court, the lawyers, everyone expected this to go a certain way because the case had ended. And 100 days later, come in and we say, actually, this isn't final. Yes, Your Honor.
But in Haddon, didn't the court make clear that the order is not final until one of 4 particular enumerated things had happened, none of which happened here?
And Your Honor, Haddon did make that clear, as did Andrews, Your Honor. And where I disagree with the premise of your question, Your Honor, is that I do think one of those 4 things happened.
Okay, which one?
Corrected the sentence. The 4 things are discharging, I think no one disputes that didn't happen. Granting him a new trial, that didn't happen. She corrected the sentences on counts 2 and 3 to 0. She vacated the counts. She gave him what he asked for. She said, correct it to 0. She did. It was over. And then what makes that a final order? Well, in general, when this court's trying to decide if an order is final or not, it leaves the district court with nothing to do other than execute the judgment. And that's all the district court could do at the count 1 resentencing. It could not go back at the resentencing and say, you know what, everybody, having given this some more thought, I'm going to go ahead and reinstate one of the 924C counts. I'm going to go ahead and reinstate them. She couldn't have done that. If she would have done it, it would have, I can't even imagine the mechanism. Well, the government is here trying to artificially create that mechanism with Rule 60. And it can't do that to substitute for appeal. What if the government had been timely? Judge Flanagan issues her order, agreed to something that maybe we shouldn't have, because look here, there's this weird conspiracy substantive issue, notice of appeal. Then it comes up to this court. And then we have, rollicking oral argument about invited error or waiver, or I'm a defense lawyer, so I understand that sometimes results that seem very unfair have to stand, and 9 times out of 10, it's my client who's left holding the bag because something wasn't timely, something wasn't filed properly. And I guess it's sauce for the goose and it's sauce for the gander, because the government, the writ was granted, the case ended, the 60-day clock started, midnight struck, and a month and a half later, they realized their mistake. I understand it. Look, these Johnson cases stress both sides. We had a lot of clients to go through, and the government had a lot of cases to go through. And by and large, and I'm sure Mr. Bragdon would agree, it was a very good partnership where everyone was working together to try and get these done in the interest of justice as efficiently as possible. And because this is a civil case and not a criminal case, that 60-day deadline is statutory and it's jurisdictional. So even if this court wanted to excuse the government's late filing of the Rule 60, this court lacks jurisdiction to hear the case. We're here anyway because it was a Rule 60, but I don't think we should be here. And perhaps more to the point, Congress doesn't think we should be here. It was a mistake, and the government has to live with that mistake. And if the court doesn't have any questions, I will see you on rebuttal.
Thank you, Mr. Brignac. Mr. Bragdon.
Good morning. May it please the court. My name is David Bragdon and I represent the United States. I wanted to touch on Haddon first, because I think the rule in Haddon is that in a habeas case, it's not final or appealable until one of 3 remedies occurred. And I think in our brief, we may have said 4 remedies, but when I looked at Haddon again at page 661, it actually divides the last 2 remedies are just subpart of remedies number 3. So
Okay, and I have a question. So opposing counsel points us to the remedy of a corrected sentence, which he says is what happened here with vacating, and that argument has some appeal. What's the government's response to that?
well, and that goes to the 3rd remedy that Haddon talks about is a new sentence, and it breaks it into 2 subparts. It can either be a resentencing or a corrected sentence. But for either of that to be complete, there has to be a new sentence. There was no new sentence here, and so the sentence wasn't corrected.
Well, if for either of that to be complete, there has to be a new sentence. Why would the case separate it out and specifically say corrected sentence? Why didn't it just say new sentence if corrected sentence means the same thing?
Actually, corrected sentence doesn't mean the same thing. If you look at the case in Haddon itself, the court corrected the sentence without a new sentencing hearing. Sometimes it does that. So on the government use the defendant's sentence to reduce the 924C count, and in that case, there was a new sentence issued, but it was done through a correction. Here, there was no correction that resulted in a new sentence. And so because there's no new sentence, the judgment is not complete. And I think that's why it's important that, Haddon is dividing this into 3 categories rather than 4, because the third category has to have a new sentence, and it will either occur through resentencing or it will occur through a corrected sentence. And here
So
there
as
was,
Mr. Bragnac said, something just doesn't feel right here. The government really made a colossal mistake, which I'm sure you would agree with. What about the injustice or faith in the government? The government would be jumping up and down about it.
well, so I think that if the defense had made a mistake that resulted in more prison time before a resentencing had occurred, maybe renewing of counts that should have been dismissed, I can't imagine the government opposing fixing that mistake. It was also corrected before the defendant was resentenced, before any
It's really
sentence was
hard to
imposed.
understand how this mistake was even made in the first place. It's 1 count, 1 sentence. The word conspiracy doesn't, which was what the vacating the sentence was based on.
The Martin case is a Ninth Circuit case. The defendant acknowledges that that case is directly on point here, presents almost the exact same facts. And when we look at Martin, the court does emphasize the importance of not having piecemeal appeals. And what it says is, if we allowed this approach, the government might appeal the habeas part of the case, and then the defendant might appeal the sentencing part, and those could be 2 separate appeals. And so it makes sense as part of finality to do those together. I would also point the court to the Hillary and Smith cases cited by the defendant. That's where the court talks about the sentencing package theory and the fact that sentences are treated as a package. It's acknowledged that a sentence in 1 count may affect what happens, or dismissal of 1 count may affect how the court sentences the other counts. So they're all grouped together. And then the defense tries to argue, well, this court shouldn't apply Martin, but this court instead actually cited Martin for the point that's at issue here. And so I think this is a case where avoiding piecemeal approaches matter. It's a case where we want to have there is a rule in place about when finality occurs. And so unless there's further questions, I would ask this court to affirm.
Thank you, Mr. Bragdon.
Thank you.
Mr. Brignac, you have some time reserved.
Thank you, Your Honor. I would first, the government talks about there being 3 remedies under 2255. I would just point this court to Andrews at the very end of page 339 on Andrews. The Supreme Court, citing 2255, lists 4 remedies in the disjunctive: discharge, resentence, grant a new trial, or correct the sentence. So there are 4 according to the Supreme Court, and so I will rely on them. The mutuality of the mistake is an interesting point. I would say that, Mathis is now binding law saying that substantive Hobbs Act robbery in this circuit is a 924C predicate. We were certainly not conceding that until this court's Mathis decision. So our position would have been that he was entitled to relief regardless of the mistake about the conspiracy or not. But I do think it's a fair reading, especially, Joint Appendix 46 is, I think on paragraph 6, the parties did misunderstand. And that's the case, but that's something we all have to live with. The government also cites the third section of Hillary. This court actually talks about the fact that, this idea of not letting the 2255 end, the defendant in that case indicated that could lead to some problems and could lead to some gamesmanship. And this court said straight up, first, we're only going to decide the case in front of us, but we will not hesitate to correct abuses of the district court's discretion if this is being gamed. So even in Hillary itself, where the court's talking about this rule, it is signaling that we're not going to let this become gamesmanship, and we're not going to let this become an end around. And the government does talk Martin. We acknowledge Martin. This court, I don't want to hide the ball. I don't see a way to come out the way I think this court should without creating a circuit split with Martin. But Martin talks about the need for piecemeal litigation, and it wouldn't be piecemeal appeals. The legal issue of correcting the sentence on the 2255s, granting the writ, ending the case is one appeal, and the substantive criminal issues related to the sentence is a totally separate appeal. They wouldn't have overlapping issues. In Stitt, the government says, yes, Stitt does cite Martin, but Stitt is not on point. The government appealed in Stitt, and it was a capital sentencing, and the count that was set for a capital resentencing was the count that was the subject of the 2255. So that's not factually similar to this case. And we acknowledge that if we were factually similar, that Stitt would control. This doesn't come up much between the two of us, and I'm sure Mr. Bragdon, spent as much time on Westlaw as I did. Martin is the only other case I've ever seen that has this factual scenario. It doesn't come up much, but what does come up a lot is that finality is important. And when a case ends, the party has a time to appeal, and if you don't appeal, you've lost your right to do it, and no one disputes Rule 60 cannot be an end around that. So we would ask the court to vacate the district court's order and remand with instructions to basically grant the 2255, take away the 2924C count.
Thank you so much, Mr. Brignac and Mr. Bragdon. Thank you so much for your arguments. We would love to be able to come down and greet you personally. We can't do that, but know very much that we appreciate your arguments, and we hope that you will be safe and stay well. Thank you so much for your arguments.
Thank you.
Thank you, Your Honor.
We'll proceed to our next case. Mr. Camden?
Thank you, Your Honor, and may it please the court. The illegal reentry statute, section 1326, is unconstitutional for two reasons. The first and most important is that the removal proceedings and the order resulting from those proceedings, which form an element of 1326, are based on factual findings. And yet Congress has forbidden the jury from reviewing those factual findings. Those facts are hidden entirely, and the jury is not given any access to be able to make an independent determination on those. The second is that these decisions, the removal orders that form an element of 1326, are essentially discretionary decisions. They're discretionary at every stage of the removal proceedings, whether to begin proceedings, who to subject to proceedings, and then even if a person is factually deportable, whether to give that person relief. And the grant rates for these, for example, we included some statistics on asylum. can be extremely high and extremely low, depending entirely on the individual adjudicator and the way that they exercise discretion. This does not comport with the Supreme Court's and this court's definition and the requirements on what can constitute an element of a criminal offense. The second
Okay,
issue.
Mr. Camden, this is
Yes, sure.
Judge Thacker. But are the underlying facts of the removal or the validity of the removal order, is that an element of this crime? Or is it simply the removal itself?
The way it's drafted and the way the Supreme Court's interpreted in Mendoza-Lopez, the element is only the bare existence of the removal order. I agree.
Correct. So why isn't that a problem for you?
Because removal orders are special kinds of facts. They're different than any other adjudicative facts, like whether somebody carried a gun or whether a person was in a certain place at a time, any of the adjudicative facts. A removal order is an administrative order that itself is based on findings of fact, right? So this is a fact, the existence of the order, that depended on other findings of historical fact by an executive official. So we have executive agency findings of fact being essentially smuggled into a case under the guise of the fact of a removal order, without the jury being given access to them. So it's helpful, I think, to illustrate if you look back at the history of this issue in the Supreme Court cases. Mendoza-Lopez, footnote 15, said, even with the safeguards of allowing a collateral attack as a pretrial motion, even with those safeguards, the use of an administrative order is troubling. But they didn't resolve it in that case. But they did cite to Justice Jackson and Frankfurter's dissent in United States versus Specter. And Specter, in turn, kind of relates back to this case. I'll go all the way back to the beginning, Wong Wing. In Wong Wing, it was essentially the entire criminal matter was referred to the administrative agency. Commissioners, if they found somebody of Chinese descent without the required paperwork, were allowed to force them to do hard labor before deporting them or impose fines. The Supreme Court said, no, of course, the Sixth Amendment requires a trial by jury before any actual punishment's going to be imposed. So this violates the Sixth Amendment. And the Fifth Amendment.
But didn't Mendoza also indicate that the illegal reentry statute is constitutional provided that judicial review is available?
It said that at a minimum, judicial review must be provided, but it did not address the additional.
Are you claiming that you were wrongfully precluded from judicial review, or that the outcome of the underlying order would change with judicial review?
No, Your Honor, this is a facial attack on the statute. We did not bring any specific facts about the removal order that occurred in my client's case. So this is the argument is.
Right.
Yeah, the Sixth Amendment requires these facts be found by jury, but the statute Congress drafted forbids that.
Okay, go ahead.
I apologize, sir. Wong Wing involved this entirely, the criminal matter being entirely in the province of the administrative agency. And then Specter comes along in 1954, and in that case, that's the first time Congress had made the order of removal the element of the crime. So it allowed the jury to determine all the facts about whether the person had refused to cooperate with the removal or the removal order existed. But it took that issue of whether the person was here illegally, and it left it with the administrative agency. And that's the problem Justice Jackson and Frankfurter identified there, is that you can see a clear development where Congress initially puts it all to the agency and then gives some things back to the jury, but keeps some things under the cover of this removal order, this administrative order, and doesn't let the jury get into those facts. But those facts are still necessary to the crime. Justice, even Mendoza-Lopez itself came before Apprendi. So in my briefing, I've tried to kind of fit that argument in the framework of Apprendi. Apprendi says facts necessary to the imposition of punishment have to be found by a jury. So whether an alien is deportable on the grounds that are alleged in whatever the charging document was in immigration court is a fact that is necessary for the removal order, which is necessary for conviction. So it's a fact that's necessary for conviction, just logically speaking. There is one, this, and I acknowledge this is not an issue that has been frequently raised and on which there are many cases and we're trying to narrowly distinguish. This is sort of an open question across the board. The one I found is United States versus England. It's a tax case from the Sixth Circuit. And it's helpful if you look at the tax context. In tax cases, the government must prove not only the existence of the order, but the validity of the order. So a person charged with evading a tax can come into court and defend on the grounds that, yeah, they issued this order, this assessment, tax assessment exists, but it was wrong. I actually didn't owe any taxes. An illegal entry defendant has no option to do that. They're forbidden in the way that 1326 was written and construed in Mendoza-Lopez. They're forbidden from saying, actually, you know what, I wasn't even deportable, or there's a factual issue where they haven't proven that I'm deportable, or there's a reasonable doubt about whether I was deportable at the time. So these are facts that are getting, essentially, the problem here is that if it helps to look at it from the other perspective. If the government's fault, and if Congress can make an administrative agency adjudication into an element of a crime, what does that allow Congress to do? If you look at, and there are cases on both sides of this. So the Subversive Activities Control Board was enacted in the 1950s over President Truman's veto. And its job was to determine whether organizations were communist action organizations and then issue orders that had criminal consequences attached. Now, that board got completely dismantled by the Supreme Court in a series of cases because of other constitutional problems with it, with the First Amendment and the right against self-incrimination. But it shows what this empowers Congress and the executive branch to do and how it can evade traditional jury requirements. If you look at, in another case, we cited the Rhode Island Commission to Encourage Morality in Youth. More recently, the Supreme Court in 2018 had the Masterpiece Cake Shop case on the other sort of political side of this, where Colorado had set up a commission that had the power to order people to sell goods, in violation as they argued against the country.
Does the fact that there is some judicial review of these orders available, does that help or hurt your argument, or it just doesn't matter one way or the other in your view to your argument?
I don't think it matters, Your Honor, because the heart of the argument is this is a Sixth Amendment right, and so whether judicial review is provided or not, no jury ever gets to find these facts. There's no opportunity for that.
Okay.
And also, even though, as Justice Jackson in the Spectre dissent identified, even the judicial review is extremely deferential to the administrative agency. So the agency gets the benefit of findings of fact. It's affirmed if there's any substantial evidence and not proof beyond a reasonable doubt. There's no right to cross-examine, or at least no constitutional absolute right to cross-examine the witnesses that provide this information, and no right to an attorney for people that can't afford it, which is almost everybody. So,
Mr. Camden,
yes, Your Honor.
can we change course just a minute and talk about the sentencing? My question is, did the district court acknowledge or even consider your client's arguments regarding sentencing disparity or his stale drug convictions?
Regarding the staleness of the drug convictions, I do not believe the district court mentioned them. He acknowledged the existence of those convictions and that they were from that age, but the argument that they were stale and therefore had a less predictive power under the 3553 factors, I didn't see that in the record. Regarding, I apologize, the other specific argument.
It's disparity.
It's disparity, Your Honor.
Your disparity argument.
The district court asked a question in the course of my argument. At the time, he asked whether the criminal history of the individuals, the cases that we submitted as comparators, were identical, and obviously they were not. Although they were similar, I didn't mention, as far as I could recall, and as having reviewed the JA, I don't believe the district court addressed that argument, frankly.
That was a very short exchange. I mean, the last thing he said about identical criminal history, you said, no, I don't think any two people have identical criminal history. And the court says, okay, that's fair. The guidelines say similar record, not identical, and then he just says, okay. That's
Yes.
the extent of it.
And this gets to the heart, I think, of the dispute is the district court clearly heard the arguments. I mean, he asked a question, he's listening to the arguments. So he heard these arguments. But the sentencing reasonableness requires that the district court not only acknowledge that the argument was made, but explain for appellate review, but also so Mr. Perez-Paz can hear it, why that argument did not serve to lower his sentence, why it did not justify the sentence that I requested on his behalf. And I think Blue and Rita and Slappy and all of this series of cases, the district court has to explain whether and why the facts that are cited in the arguments move the needle on that 35-3A factors. The government cites Arbaugh, which is a case that came out earlier, I believe late last year, or possibly earlier this year. It's a very recent case for the bare proposition that the district court need not address every argument that's made. That's a very qualified statement, I think. The district court need not address any non-frivolous argument or any frivolous arguments, but the other cases well before that are published cases do require the district court to address non-frivolous arguments. And I'm not saying it has to be expansive or in-depth or super detailed. It's just, Mr. Perez, your attorneys pointed out that the convictions are 20 plus years old and therefore that they don't really tell me much about whether you're likely to recidivate if you're released. I acknowledge that, but it's outweighed by this. Or I, disagree with that. I think actually it does tell us something about your behavior today or in the future that we can predict. So all they have to do is finish that sentence with, I agree with it, but it's outweighed by, or I disagree with that because, and there'd be enough, at least, for this court to review and for Mr. Perez-Paz to go and serve his 46-month sentence, knowing at least that the district court heard what his appointed attorney said, and so he can serve that sentence, knowing why he's there. And so those are the arguments, I think, and that's really the heart of the matter is that the district court has to address it under the 35-3A factors and not just acknowledge the argument. If there are no further questions at this point, I think I'll simply reserve the rest of my time. Thank you.
Thank you, Mr. Camden. Rano?
Morning, Your Honor. May it please the court, I think what it boils down to, as Mr. Camden just acknowledged, the sort of whole heart of his argument is grounded in the Sixth Amendment jury trial right. But the Sixth Amendment has never been used to expand the statutory elements. It's simply made that when a fact is in a criminal statute and is relevant to punishment, that fact must be found by a jury. In fact, the Supreme Court said explicitly in Schreiero that the Sixth Amendment does not affect the substantive range of conduct that Congress can prohibit. When we combine that with the statement from the Supreme Court in Mendoza-Lopez and this court's decision in Hammoud about the designation of a foreign terrorist organization, I think those two cases disprove the idea of a transitive property of statutory elements, that some fact necessary to something Congress has made an element of a criminal offense itself becomes an element of the criminal offense. Once we're in this context, Mendoza-Lopez was very clear that the validity of the removal order is not actually an element of the statute, and therefore there's nothing for the jury to pass on when it comes to that. Mendoza-Lopez was concerned primarily with a lack of due process ability to challenge or obtain judicial review of the proceeding in the first instance at all. And that was an animating theme in the cases that Mr. Camden has been citing, including Yakis and Wong Wing. Specter, too, even Justice Jackson's dissent in Specter was focused on the lack of ability of the defendant to challenge the use of an administrative proceeding as an element of his statute, whether that was validly passed at all. And I think when we take Congress's amendments to 1326 into consideration, Congress has actually adopted a very protective statutory framework for defendants in this context. They are guaranteed judicial review of the validity of their removal order, including in cases, as this court recently held, where expedited removal prevents judicial review in the first instance. This court just recently held that, in fact, a defendant in a 1326 proceeding can collaterally challenge an expedited removal order and obtain judicial review of that validity. So we're not dealing with the kind of concerns that I think are animating Mr. Camden's argument about Congress hiding the ball or hiding facts behind administrative agency determinations. This is a context in which the gravamen of what Congress has punished is after having been told that an individual is not permitted within the United States under the immigration laws, they then take steps to do so anyway. It's not the direct criminalization of an agency adjudication, and I think that makes a difference. Turning to Judge Floyd's questions about the sentencing, I think this court has been very careful to walk a line between requiring enough comment in the sentencing procedures to allow for effective appellate review and to provide an explanation to defendants while not micromanaging the sentencing process. And I think that's the tension between cases like Arbaugh on one hand and Blue on the other. Mr. Camden suggests that this decision would have been fine had the district court said, I agree or I disagree, but, and I think at that point, that's tending too much into the micromanaging aspects of the sentencing procedures. Here, the district court made it very clear that it was engaged with the arguments, and when it provided the sentencing explanation, it said what it thought was the most critical factor, which was the lack of deterrence over a consistent period of time. Once the district court has, in fact, acknowledged, as Mr. Camden agrees, that he heard these arguments, that he considered these arguments, and then says, but this is what I am basing my decision on, I think that's sufficient under this court's precedence.
Counsel, you mentioned this word, I'm using your words now, that the court ought not to be engaged in micromanagement. But isn't that exactly what individualized sentencing is? It's not the macro, it is the micro.
For a district court, absolutely, Your Honor. The district court is required, in fact, to make individualized determinations. I think cases like Arbaugh say that this court is not engaged in micromanaging the district court's adjudication of a particular sentence. So while the district court is absolutely applying an individualized...
My point, though, is, right, we're not micromanaging, we are reviewing, and that's the key. It needs to be enough in the record so we can review it. So the problem is if it's non-existent or so micro, if you will, is like you can't even see it, it can't be reviewed. So it does require, and Slappy and Blue, you know, non-privileged, you talk about the circumstances, those things in terms of the trauma, in terms of his family and the needs, those things are not, you think those are frivolous?
Not at all, Your Honor, but I would say that the district court actually addressed them in this context. It pointed out the fact that, for example, Mr. Perez-Paz's concerns about violence in his home country, it said, I find them distinguishable because it were directed at other members of his family. With respect to his motivations for coming to the United States...
Excuse me. Think about that. Because it was his brother, wasn't it?
Yes, Your Honor.
And the district court said because it wasn't directed toward him?
Yes, Your Honor. And Your Honor, again, this is in the whether or not the district court made abuses of discretion. The district court has a wide degree of discretion as to what it can find relevant to sentencing and how it balances those factors. But the argument that Mr. Camden has made is that the sentencing explanation was adequate. And I think here, I think the district court did enough. It may not have been exhaustive and it may not have been as comprehensive as the defendant or Mr. Camden would have wished. But I do think the district court was conscientious that it acknowledged the arguments raised and explained why it was picking the sentence that it did. If the court has no further questions.
So what you're saying is that, this is a hypothetical. You're saying that if, for example, is a case where a person had lost all of their children in a fire, and they're sentencing that trauma, as long as the judge said, I understand that you lost all the children in the fire, but it wasn't you who was burned up, that would be enough.
For terms of a sentencing explanation, Your Honor, yes, I think it would. I think if the district court says, I've considered this argument, but I find this factor outweighs it, and I balance the 3553A factors to come to X sentence, I think in terms of this court's sentencing explanation precedents, that would be sufficient.
Oh, you said, I don't care. Same thing, right?
Yes, Your Honor, although there's a separate, I think there would be other challenges that a defendant could make, perhaps to substantive reasonableness about including or disregarding whether or not the balance was so out of whack that the district court had abused its discretion in coming to the conclusions or had abused discretion by weighting one factor too heavily, things like that. But again, in the sentencing explanation context, all we're looking for is that the district court has in fact acknowledged arguments made by the defendant and stated its reasons for imposing the sentence that it did in light of those arguments.
The case law says consider, it didn't say anything about acknowledging, just acknowledging.
Well, yes, sir. I think consider and acknowledge are similar. I think if the district court says, yes, I hear you, and then says nothing else, that probably is not sufficient. But here the district court said, yes, I understand, but I find this to be the most important factor in this case. And I think that indicates that the district court was engaged in the balancing of 3553A factors the statute requires. Unless the court has any further questions for me, we will rest on our briefing.
Thank you, Mr. Brownell. Mr. Camden, you have some time reserved.
Yes, Your Honor. Regarding the threats, it was not only his brother. After his brother was murdered, the gangs actually arrived at his sister's house and made threats to her and said, if you don't leave here, what happened to your brother is going to happen to you. That's and there was actually an affidavit we provided. That's at JA 172. And the government essentially is making the argument as to the sentence that if the district court acknowledges it, the argument in mitigation, but then says some other factor justifies the sentence that it's giving, that automatically we can infer that the district court thought that factor was outweighed. And I don't agree with that. I think the cases are clear that if the district court believes that this factor outweighs the arguments in mitigation, it has to say those factors are outweighed by this, or I agree that a lower sentence would be justified, except the need for, say, deterrence or protection of the public is higher in this case and won't allow me to go down and give effect to those. When I suggested that the district court could finish a sentence saying, I agree with this, but, or I disagree, but that's not exclusive. And to rebut the micromanaging point, it doesn't have to be in any particular formula. And it can, in fact, be in the course of the argument. If the district court interrupts and has questions and has a discussion, just like we're having right now, that make its views clear about what it thinks about the argument under the 3553A factors, then that's enough. It just has to be somewhere in the record. It doesn't have to be a formal pronouncement. But to present, his brother's death certificate, his sister's affidavit, the testimony of his wife about the surgeries she's endured, his United States citizen son's birth certificate and the circumstances regarding his abandonment by the biological mother. And then to make an argument tying all those to the 3553A factors and then hearing nothing except for the factors that are an aggravation in the explanation of sentence. Just I don't know what the district court thought. I don't believe the record allows anybody reading it to conclude what the district court made of those arguments. And that's the reason we need a remand of the sentence. If there are no further questions on the sentence, which I'd like to answer any questions the court has on that. If not, just briefly to go back to the Sixth Amendment problems, judicial review does not cure this problem. The government relies on 1326 and says people there under 1326D, which governs collateral attacks, are guaranteed judicial review. They're not, because the government routinely argues that judicial review was available, but the person didn't avail themselves of it previously or didn't exhaust their administrative remedies to avoid reaching the merits of whether a person was deportable as charged. There's a Supreme Court case now, Palomar Santiago, where the person was a lawful permanent resident. He was ordered removed because of a DUI, which we now know after Leocal is not even a grounds to remove the person. So he should still be here with his family. But the government is arguing right now that because he had failed pro se to appeal administratively this determination at the time, years ago, before a criminal case without a lawyer, that he's prohibited from collaterally attacking it now. And a jury is never going to get to and didn't get to under the way 1326 is drafted, didn't get to say whether he was deportable at the time. This is a very easy issue for Congress to cure. It can make the validity of the warrant an element again, like it did before the current amendments to 1326. One last note, the government cites Hamoud. These terrorist cases and the designation of foreign terrorist organizations are rules of general applicability. These are not agency adjudications. So when Congress or the executive designates an organization as a terrorist organization, that means I can't contribute money to it. John Doe on the street can't contribute money to it. It's a regulation that applies to everybody. So I'm only challenging the use of adjudications. So these are individuals that appear before administrative agencies and are ordered to do something. And really, we need to look at the flip side. The problem here is that the government wants to extend contempt power to administrative agencies. Judicial orders against a person can be enforced by imprisonment if the person doesn't obey it. But in no other circumstance has Congress allowed an agency to issue an order and then provided for criminal felony punishment of a violation of those orders without the fact finder in the criminal case being able to review the facts that went into the order itself. Contempt is an Article 3 power. It's an inherent Article 3 power necessary to the adjudication or to the exercise of Article 3 powers, and extending it into the executive branch is a bridge too far. It is giving far too much power, and it would violate separation of powers concerns. I see my time is up. And I thank you for the argument.
So I'd like you to respond to this and help me because that, and I understand your argument in terms of looking at the idea of from apprende and fairness, but hear me out first and then try to, I'm not making comments, these things I want you to think about. When you talk about a right to a jury trial, isn't the problem is this is one of these kind of rare kettle of fish where fairness really, unfortunately, has nothing to do with it, unfortunately. Because you're right, you could be deported. It's a body of discretion. For example, A can have the same situation as B, but by the discretion of the Attorney General in that process, they say, we're going to grant you to allow you to stay, another person deported. So even if a jury had that question put to them, what would they determine? They would still have to judge it by discretion. It wouldn't be, well, wait a minute, if I were deciding this case, I never would have deported him. It can't be that, right? It would still have to be what they would decide whether or not it was a proper. See what I'm saying? Baked in there is the discretion that, you know, for example, only even our court, for example, we can't grant asylum. We can look to see whether or not there's a violation and send it back, but only the Attorney General can grant asylum. Even this court can't. So I mean, for example, so how would you do that? What would that look like in terms of jury instructions for a jury to determine it? Even though you're right, it impacts sentencing, but how could it? Tell me.
In my briefing, Your Honor, I think I identified that problem. It's the second argument, sort of under the Fifth Amendment, that this discretion goes into the orders as well as factual findings. I don't frankly have a good solution to that. I think it is a problem, and I think it's a problem that implicates the Fifth Amendment. But you're right, this is not a factual determination or even a mixed question of fact and law under Gaudin that would still go to the jury. It's essentially a value judgment. I think one solution would be that you could treat it as a mixed question of fact and law under Gaudin, then that would go to the jury, and the jury would just decide, whether this removal order should have entered. I don't think Congress intended that with 1326, so I don't know that the court could remedy it that way. That's the whole problem I've got with this. Is we could remedy it. If you could remedy it by striking things, that'd be fine, but we can't remedy it by adding stuff to the statute that lets the jury get the things Congress didn't let them. But I think that's the problem with these purely discretionary orders. The two people identically situated, one goes in front of immigration judge A and gets asylum and is here. The other goes in front of B and gets asylum denied, judicial review denied because it's deferential, deported, and then comes back to see his family or because of threats in his home country, and he's charged with 1326. And the only thing that separated them is the executive discretion that was being exercised. So I don't think there is a way. Elements have to be factual findings, and so there's no real way to submit that to a jury, and it's just another reason why 1326 violates the Constitution.
All right, thank you. All right, Mr. Camden, Grano, thank you so much for your arguments. We can't come down and greet you personally as we would do in our wonderful tradition, but nonetheless, we very much appreciate you being for your fine arguments on these difficult cases. And I wish that you would be safe and stay well. Thank you so much.
Thank you.
Hunter.
Would you like to take a break?
Start.
Everybody's here? Yes. Mr. Robinson, you may proceed.
Good morning.
Morning.
Thank you all. This is my first argument in the Fourth Circuit, so here we go. I think that the issues in this case before the court are very clear with regards to my client's position. All the facts or factual, not findings, but facts and circumstances are conceded at this point as far as.
Mr. Robinson, just for my clarification, do you represent Mr. Moody or Ms. Carter?
I represent Ms. Carter.
All right, thank you.
Okay, sorry about that. As I was saying, all of the testimony, all of the evidence is truly undisputed. You know, the question remains whether or not there was substantial evidence sufficient for a finding of guilt and to support the conviction, and I submit that there was not. As I said, I'm not disputing any factual issue such as the basis for the stop, or should I say the stop, the observance of furtive gestures of a passenger, car pulling over, and the officers coming into contact with both driver and passenger. My client was the driver. And then the subsequent discovery of certain items. Not disputing where they were found and when they were found. There was a Glock 22 found under the passenger seat. There was a Glock 43 found behind the driver's seat. That's my client. Next to and among other debris and items in the car, that Glock 43 that was found behind the driver's seat was next to a bag which contained the suspected narcotics. Also inside that bag was gloves, packaging material, the drug itself, and a charger and a digital scale. No question that the items found may have been consistent with, or should I say inconsistent with, personal use.
Okay, so Mr. Robinson, was the Glock, the Glock 22, that was under the passenger seat, right?
Correct. Not readily visible, but yes.
Exactly, that's my point. That seems like a good point for you, that while the magazine for the Glock, the other Glock, was in plain view in the console, the Glock 22 is under the passenger seat. Your client is the driver. Yes. And this was not in plain view. So could you make your argument about that particular count with regard to your client and the Glock 22?
Yes, with regard to the Glock 22, it was not open and obvious, although it wasn't in a closed container, not readily visible by the occupants of the vehicle or by law enforcement who came upon it.
And your client was not the owner of the vehicle, correct? Even though she was driving? Correct.
Only the operator.
So that's.
It was, I believe it was undetermined as to who owned the vehicle or who was registered to.
Is it true, Mr. Robinson, that Ms. Carter bought that firearm hours before her arrest?
Not bought the firearm, Your Honor. She had reclaimed it from a pawn shop, I think within a day or so of being stopped by the officers. That's what the government's witness had disclosed from her signing the pawn sheet when she reclaimed it.
And so that's the one that was under the passenger seat?
Behind the driver's seat, Judge. The one behind the driver's seat was behind.
Okay, she reclaimed the 43 from the pawn shop. Okay, yes. Nothing to do with the one under the passenger seat that she couldn't see.
Correct. Correct. And getting back to where I was with the firearm in some proximity to the bag that contained the drugs and the scale and the other suspected items, the drugs were in a closed container. My client made no furtive gestures towards that item. There were no forensics, no DNA, no prints, or identification or any other identifiers in that bag to connect it to my client. It is just mere proximity, mere location. None of the government's witnesses could testify as to how, when, and by who the item was placed into the vehicle. Talking about the bag that had the contraband in it, not so much the firearm, because there is a trail of, or should I say, a knowledge trail with regards to her reclaiming it just before the stop. And I believe I'm just about out of time, so I'll reserve some for rebuttal, if there are any other questions.
Mr. Robinson, Mr.
Yes.
Bodner? Yes. You're muted. You're muted. You're muted.
He's trying.
Can we get him some help and get it for him?
Thank you, Your Honor. Thank you for your patience. I apologize for that delay.
No problem.
May it please the court, my name is Mark Bodner, and I am counsel for the co-defendant in this case, Mr. Marcus Moody. And Mr. Robinson has well pointed out the facts in this case, and I think the ones that really speak out for my client are, and where I think the jury was wrong, was that the government did not prove that my client had any knowledge of the firearms or the drugs. As indicated, there was a gun under my client's seat. The evidence showed that you could not see the gun if you were in the seat. In fact, the officer who conducted the stop indicated quite expressly that you had to look under the seat to know that the gun was there. There was no other evidence to connect my client with that firearm or the one behind the driver's seat, or I should properly say under her seat and in front of the bag of the drugs. They submitted the firearms for testing, both for DNA and fingerprints, and they came up with nothing. So there was no connection there. And the same goes for his exercise of dominion and control. There was nothing to show, because of course he lacked knowledge of either of these firearms, that he ever exercised dominion or control over either the drugs or the weapons. And there are two cases that really point out well the government's problem and the mistake that the jury made, because our position essentially is the jury could not have found, based on the evidence presented, beyond a reasonable doubt. They might have had a suspicion that something was afoot, that something unlawful was afoot, but they didn't have evidence beyond a reasonable doubt to show that Mr. Moody either exercised control over the guns or the drugs or knew that they were there. This court decided a very similar case back in the 90s, United States versus Blue. It's at 957 F. 2nd, and I have the page number also. And there was another case from the Second Circuit following Blue that is quite similar as well, in Cherez in the Seventh Circuit. And both of these follow exactly the kinds of facts that we're talking about. Now, our case is a little bit different in that the officer claims that after he conducted the stop or made the stop, and as he was alighting from his vehicle, he saw my client reach behind the seat and make furtive movement, but he couldn't see what was in my client's hands or whether anything had happened. He saw him lean forward. He couldn't tell what was happening there either. But that's addressed in Blue, because this court in Blue, and there are two Blue decisions. One's a vehicle stop, and one is a search of an apartment in a conspiracy case. But the one I'm referring to is at 957 Virginia, the vehicle stop. In that case, this court said that the movement of the passenger, in which his shoulder was shown to make a movement, was not sufficient to show that the passenger had possession and control of the firearm that was discovered under his seat after the vehicle was stopped. Another parallel in that case to ours, the government seems to think that there's a significant factor in that my client had a significant amount of money in his coat when he was searched by the officer who stopped, Officer Polino. In the case I cited you, United States versus Blue, this circuit 957 F second, the passenger in that case also had a syringe and a small amount of drugs on his person, and apparently that was not enough to convince this court that the evidence was sufficient beyond a reasonable doubt to show that that passenger had exercise and control over the gun that was found beneath the seat in the car in which he was a passenger. As this court well knows, and as I think Mr. Robinson just alluded to, proximity to these items is not enough. I'd like to address the part where I believe the government is trying to make the case that there was a conspiracy here, and therefore they had knowing possession of the firearms. And these were the fact that the existence of the gun and the drugs in the car was evidence of the conspiracy. You know, this was a vehicle stop that appears to have taken place under a very short time. The government did not show any evidence to show that these people knew each other than when asked about my client's dipping his hand behind the driver's seat. Officer Polino elicited the response, my client said, "That's my girl, that's my girl." Other than that, we don't know how long their relationship was. We don't know how long they were in the car. There was no evidence to show that they had been in business together. There were no buyers list. There was no paraphernalia found on my client, just money. Although it was, according to the government's expert, it was packaged in a suspicious way. That was, it was bundled. But my client explained that by saying, dice game, dice game, dice game, and that's where he had gotten the money. So the government takes all this information, all these circumstances, and I understand that a conspiracy may be proved by circumstantial evidence, and often is, but if you'll note the cases cited in the government's brief, and as I point out in our reply, almost all those cases involve numerous people involved in the conspiracy and conducting activities over an extended period of time in which they're surveilled. In our case, it's a photo flash, a screenshot, and what we have is the government's using both the gun and the drugs, which, as I pointed out, were not proved to be within my client's dominion or control, or that he even had a knowledge or awareness of them, to bootstrap into making a conspiracy argument that therefore, because these items of evidence existed, that is evidence of the conspiracy. So I see my time is almost up. I'd be happy to answer any questions the court may have.
Thank you, Mr. Bodner. Ms. Taylor?
May it please the court, Kristen Taylor on behalf of the United States. Your Honor, substantial evidence in this case does support the jury's verdict as to both defendants on all counts. Yes, most of the evidence is largely circumstantial, but as this court is well aware, the law does not differentiate between circumstantial and direct evidence, and it is entirely proper for the jury's verdict to rest solely upon circumstantial evidence. The circumstantial evidence in this case is very strong. Mr. Bodner mentioned United States versus Blue. Our case differs from United States versus Blue in terms of the circumstantial evidence on both a qualitative and quantitative basis. In this case, we have two people in the car and two guns. Those guns are strategically located under the driver's seat and the passenger seat, respectively. Both of those guns are loaded, chambered. There is ammunition for the Glock 43 located in plain view, in close proximity and within reach to both defendants. The defense attempts to minimize the importance of Mr. Moody's statement as to stating that Ms. Carter was his girl. He made that statement multiple times, and from that, the jury was free to properly infer that an intimate relationship existed between these two individuals. It's an important point because it changes the game in the sense that these are not just two people in a car together. Now this is a boyfriend and girlfriend driving around in a car together. And that fact is important, maybe not just positive, but certainly an important fact to consider in the totality of the circumstances, the way that this court and the way that the jury should consider the evidence in this case. In addition to the strategic placement of the weapon, it's also important that testimony came in regarding the placement of those weapons specifically. So Officer Polino testified that the Glock 22 that was underneath the passenger seat was only accessible from the front. In addition to that, the Glock 43, which the defense does not dispute belonged to Ms. Carter, was only accessible from the rear. Now recall that Mr. Moody was observed by Officer Polino.
So, Ms. Taylor, with regard to Ms. Carter, the Glock 22 you say was only accessible from the front, but it was under the passenger seat and not visible. So she, in the driver's seat, could neither see it nor arguably access it, since you said it was only accessible from the front. The Glock 43, and I understand there are other circumstances with regard to her and the Glock 43, but the Glock 43 was under her seat but only accessible from the back, so she couldn't get to that one either.
That's correct.
With respect to the Glock 22, which she couldn't see, and she didn't own the car, and she couldn't access it from the driver's seat, what is the sufficient evidence for the jury to convict her on that count with regard to the Glock 22?
The circumstantial evidence in its entirety. So again, you can't point to any one specific piece of evidence and consider that alone, but the circumstances in its entirety, particularly the fact that she was the operator of the vehicle. This circuit has recognized that a person who affirmatively exercises dominion and control over a vehicle containing weapons and contraband.
But have we ever held that a driver of a vehicle without proof of ownership, and when she is not the sole occupant in the vehicle, has dominion and control over things in the vehicle that she can't see? Have we ever held that?
I can't speak to that specifically. I know that I reviewed United States versus Herder and United States versus Armstrong, but you're right to say that in those cases, the defendant was the sole occupant of the car. I think that's where the relationship between these two individuals comes into play, and it's important. The two of these, again, a boyfriend and girlfriend, jurors know what that means. They know what boyfriend and girlfriend mean. There's a certain closeness, connotation of closeness between those two people.
Ms. Breeden, you acknowledge, you concede that your case is all circumstantial evidence in terms of the weapons. You conceded that.
Yeah, largely circumstantial case, but strong circumstantial evidence.
Now, you said the girlfriend relationship is established. All he said was, "That's my girl. That's my girl." What relationship did you establish? I mean, government had a chance to do that, right? What beyond those statements was at trial introduced to the jury?
That was the strongest piece of evidence, of course, suggesting
that was it. Well, you charging someone with a conspiracy,
right? And that's
wait a minute. I have a question. And at trial, that's all you come up with, is someone defined her as my girl.
So that I'm sorry, Your Honor.
Is that it?
So in terms of the relationship between Mr. Moody and Ms. Carter, yes, that's the most important fact going to that factor. But that's just one factor among many that Your Honors have considered in previous cases in establishing a conspiracy between two or more people. United States versus Burgos established several factors that Your Honors consider when deciding whether or not a conspiracy takes place.
All right.
That includes, I'm sorry, Your Honor.
Go ahead. Go ahead. Tell me the ones that relate to you.
Certainly, that includes the relationship between the participants. Sometimes that's not altogether clear. Sometimes you have a
relationship. All you have is a statement that somebody said, "That's my girl." That makes a relationship.
We do. We also. Oh, I'm sorry, Your Honor.
No more than saying if he called her by name, that means he knows her name. Is that a relationship?
No, he specifically said, "That's my girl," and he said it multiple times.
Well, if calling her by name is not enough, how is this nondescript term "girl" stronger?
I think saying her name would actually not have been as strong in terms of circumstantial evidence suggesting their relationship. I mean, just saying somebody's name suggests that you might know them, but it doesn't suggest anything about, what is going on between them. He said, he used a possessive word. "That's my girl." He didn't say this is a girl. This is Ms. Carter, he said, "That's my girl." And there's a common understanding as to what "my girl" means. Now, certainly, the jury could have inferred, could have absolutely reasonably inferred from that statement that the two of them were in a relationship together. They were also traveling at 3:40 in the morning together in Ms. Carter's vehicle. And so that circumstance can also be taken into consideration by the jury, to consider what type of relationship these two people have. I also think it's an important fact.
Even if they're boyfriend and girl, or especially the things that were not in plain view, certainly boyfriends are not often honest with girlfriends.
That's true. That's true. But again, that's when I ask your honors to kind of pull out from focusing on any one fact alone and looking at the circumstances altogether. Again, so you've got two people in the car. You've got the statement, "my girl." You've got Ms. Carter just hours before. Again, the stop took place during the early morning hours of December 30th of 2018. But on December 29th of 2018, Ms. Carter went back, and it's an important fact that she repurchased a gun that she had pawned in October of 2018, October 29th. She initially purchased it October 29th of 2018. She pawned it just a couple of days later on November 5th of 2018. And then we're asking the jury to say it was just a coincidence that hours before, these two people were found inside of a car with 75 grams of cocaine, packaging materials, a scale. She went and repurchased that gun. That gun was then ready to go. It was loaded, and it was chambered, and it was underneath the seat. The Glock 22 had the exact same placement: loaded, chambered, placed under the passenger seat. Again, there can be an innocent explanation for any one of these facts alone, but when you consider these facts together, they become more and more persuasive. It's a chain of reasonable inferences, one after another. And that's what the jury did in this case. They drew one reasonable inference after another and arrived at the conclusion that they did. Again, whether your honors think that as to any one particular fact, the jury could have gone the other way, that's not the question. The question here is whether it was irrational for the jury to have gone the way that it did. And in this case, you just can't say that it was irrational for the jury to believe that based upon these statements, based upon the circumstances, they arrived at the conclusion that they did.
Ms. Breeden, isn't this a stretch for conspiracy? I mean, you have drugs, okay, the packaging and the amounts and the money, that possession with intent to distribute, but conspiracy, isn't that overreaching in this case?
I don't think it is, Your Honor. I think that it's very clear. I mean, a conspiracy doesn't have to be a formal, extensive agreement. It just has to be a tacit agreement or a mutual understanding between two or more people. And I think the facts in this case certainly suggest that there was that mutual understanding between Ms. Carter and her boyfriend, Mr. Moody. Certainly the facts suggest in this case that Mr. Moody could have very well been the drug dealer in this case. He had the money on his person. He had that money.
We have cases that say that just because someone was driving someone, that's not enough to say they're involved in a conspiracy. I mean, because what you're taking just because he describes her as my girl, you're then roping her into a conspiracy. That means, for example, you sitting in the car, all it would take is someone to say, "Oh yeah, that's my girl right there," and that means she's guilty of conspiracy with everything that's in the car.
Not at all, Your Honor. Actually, that's not the only fact that the government has pointed to. Yes, that is an important fact. It is an important fact that she was driving the car. And another important fact is the time of day. Another important fact is his statement that that's his girl. But in addition, again, I'd point your attention to the fact that she went and repurchased that gun. And that's just a really big coincidence to ask the jury to accept. I mean, you're now saying that it is just a very big coincidence that day, just hours before that stop, she went back to repurchase a gun that she had pawned. And then the jury was also aware that her boyfriend, but the ready and easy access to firearms certainly isn't there. She was not a felon at the time. And so she certainly.
Ms. Taylor, let me ask you this question. On your theory of the case, suppose the two defendants had gotten out of the car and Ms. Carter said, yes, that gun under my seat is my gun. The other guy says the gun.
Because you don't have to have any ownership whatsoever over a gun to be charged with constructive possession of that gun. So who those guns belong to doesn't really matter. I mean, it's certainly a factor to consider. I think it goes to knowledge, it goes to, to that element. But whether or not, that Glock 43, just because Ms. Carter owned that gun and purchased that gun and doesn't dispute that, doesn't mean that Mr. Moody wasn't aware of the presence of that gun and was in constructive possession of that gun. He could have exercised dominion and control over that gun himself by reaching behind the seat, or he could have exercised dominion and control over that gun through Ms. Carter. Either way, he's in constructive possession of that gun. I would also.
Before you leave that, just one question. Under your theory of the case, or not just theory of the case now, in terms of evidence before the jury, what was the act in furtherance on the part of Ms. Carter for the conspiracy?
I think that there would be arguably two. I think her driving the vehicle, transporting the drugs and the contraband, and I think the repurchase of the weapon was another affirmative act in furtherance of the conspiracy.
Right,
so I think that you could point.
You're trailing off. Driving the car, and what else?
Driving the car, and then the repurchase of the Glock 43, and placing that, the one that was present under her seat. I think that that's another affirmative act in furtherance of the conspiracy. Because again, look the amount of drugs that were in the back seat. And I would also note that her gun that she knew about.
What was the amount of drugs? 75?
Approximately 75 grams of cocaine.
Grams.
And then correct.
And that's how many ounces is 75 grams?
Not sure. I can't do the quick conversion, but
it's a little less than 3 ounces, right?
I can't say for sure. But what
it's not a lot. My point is, you said the amount of drugs. That's not a lot.
Well, it is. It's
easily, readily concealable.
It has a street value of between $8,000 to $10,000. And I
think the value doesn't make it a large amount such that he, for example, couldn't have readily concealed it from her. Could have put in his pocket that amount.
Well, it was placed in a Nike drawstring bag. But again, I would point to the fact when it comes to the quantity of the drugs, 75 grams, a typical user amount is about 3.5 grams or an 8-ball. So when you consider that in light of the 75 grams, that's what the jury heard. That's the substantially
right.
more.
I'm not discounting that that's a sufficient amount to show intent to distribute. I'm questioning whether it's a sufficient amount for Ms. Carter to have known that it was there, because you just said something about the amount of drugs as being evidence of a conspiracy.
Yeah, I understand what you mean. I would point your direction to 2 pieces of evidence to suggest that. Number one would be the fact that her weapon that she knew about, that she had to have placed under that seat within hours of that stop, was only about 6 to 10 inches away from the bag containing the drugs. So that's one fact that I would point your attention to. The other,
and the magazine for that weapon that she had she'd gotten back from the pawn shop, that was in plain view in the console of the car, right?
It wasn't in the console. It was under the temperature controls. So when you look at the front of the vehicle, it's in that area where sometimes you put change or something like that.
Right. So okay. Plain view though for her.
Correct. Plain view for both and within reach of both defendants. I wanted to also point your attention to the fact that 54 of that 75 grams worth of cocaine was in compressed powder form. And that fact also came in through testimony. And Sergeant Ronneberg explained what that meant. Compressed powder is typically broken off of a kilo, and that's how dealers typically purchase that, and then they take it and they break it down for further distribution. So part of the cocaine was in powder form, part of it was in this compressed powder form, which suggests, I mean, it certainly isn't dispositive of, but it suggested it was recently purchased. So the jury could have inferred that that was a recent purchase. And of course, these two individuals are together late at night. Mr. Moody has this money on him. And so I think that that would be another fact that you would want to point to. And then again, with regard to Mr. Moody, his furtive gestures toward those, toward those items. I believe the defense suggested that, there was no other evidence that he had knowledge of these items in the car, the drugs or the guns. Well, although Blue says furtive gestures alone aren't enough, I've just discussed a whole lot of evidence that's not in United States versus Blue, but the affirmative movements are important because it does suggest to the jury that right before Officer Paulino approached the vehicle, Mr. Moody was reaching behind the seat, not once, but twice. He reached behind the seat twice. Is it a coincidence that there was now a gun found in an area consistent with one of those movements and the 75 grams of cocaine in the bag in an area consistent with that movement? Then he made a third gesture. He ducked out of view, which is consistent. Again, we find the Glock 22 with the butt facing forward. So the butt of the gun facing forward towards the front of the passenger seat, and he makes a movement toward that. That's a lot of coincidences to ask the jury to accept. And then finally, I would also point, Your Honors look at evasive behavior as being important evidence in furtherance of constructive possession. Although the testimony established that they weren't super evasive when Officer Paulino came up and started talking to them, there was evasive behavior prior to the stop. Officer Paulino didn't stop the vehicle right after the initial traffic violation. He actually just directed his attention at the vehicle at that point, and he followed behind Ms. Carter. At that point, again, consider the facts. 3:40 in the morning, there's only one other car out on the road. The speed limit's 25 miles per hour, and she is tailgating the one vehicle on the road. She's swerving over the parking lanes, almost hitting parked vehicles. That also constitutes evasive behavior that occurred just before Officer Paulino observed those furtive gestures. So I see that my time is up. If Your Honors don't have any other questions, we respectfully ask that you affirm the defendant's convictions on all counts. And thank you for your time this morning.
Thank you, Ms. Taylor. Mr. Robinson, you have some time reserved.
Okay, I'll take up some of the issues that the court and the government raised. First of all, Mr. Moody referring to my client as my girl. Now that is open to lots of interpretation. Does that mean it's a girlfriend, just met a Tinder date, a friend from high school that you just reconnected with, wife, baby mother? There are so many interpretations of that with varying degrees of acquaintanceship. So I would submit that since there wasn't any fleshing out of that, our clients didn't testify. There was no other testimony regarding any other statements that they made. So with that still open to interpretation, it still a question for the fact finder. We submit that the fact was just not met. The government has described what's called evasive maneuvers. Now, the vehicle nearly hitting another car, swerving out of its lane, these were not things that were done in response to lights or sirens being activated. These were things that were observed by law enforcement. Swerving into a lane, almost hitting a car, you're not necessarily evading anything. You're driving a vehicle, probably not very well, but that provided the basis for the stop because the officers are community caretakers and they were out there doing their job. So again, we don't have any statement, no objective science as far as DNA prints, anything on any of the contraband in the car. We would only concede ownership and or possession at the most of the Glock 43, which does have a paper trail on it leading directly back to my client. The government indicated that my client was aware of Mr. Moody's status as a felon. There was no testimony to that. She did not take the stand, and there was no other investigation that revealed a statement to establish that suspicion. So I'll submit in the end, this case only arose to the level of suspicion, and that the government did not carry its burden and should have produced an opposite result. We're asking you to vacate the convictions.
Thank you, Mr. Robinson. Mr. Wagner?
Thank you for the court's technical assistance. I am having trouble unmuting my machine today. I don't know what it is. Mr. Robinson has just essentially summed up what this case is about. If I didn't state it in my opening argument and his as well, that this is a case upon inference and not proof. And of course, the jury is going to be tempted. And of course, the jury found, because how often does a jury encounter these kinds of situations? But when they hear these kinds of dangerous weapons and they see these things happening and they have the expert come in and testify that this is the nature of the trade. But what's missing is what I indicated when I first opened this case. There was no evidence to show the awareness of the weapons. There was no evidence to show the awareness of the drugs. When the people were stopped, when Miss Carter and Mr. Moody were stopped, the officer testified that they were calm. That's totally inconsistent with the argument that Miss Carter was conducting evasive activities with the car. Now, of course, the jury has discretion to decide what to believe and what to place emphasis on. But this court's obligation, of course, in reviewing the case is to assure that there is evidence to support these things and that they are not drawn just upon inference and inferences that the jury could suppose this, the jury could suppose that. This court is the gatekeeper to assure that there is evidence to support the assertions that the government has made and that the jury had to find under the instructions in the law. Unless you have any questions, I'd submit and ask that you vacate these convictions.
Thank you. Mr. Robinson, Mr. Bodner, I note that you're both court appointed. Thank you on behalf of the Fourth Circuit, lawyers like yourself. We could not do our work without you all doing this work and this assignment, and we really appreciate it. Thank you very much. And Ms. Taylor, we note your able representation of the United States. We can't come down and greet you by hand, as we love to do in our tradition, but know that we very much appreciate your fine work and wish that you would be safe and stay well. Thank you so much.
Thank the court for hearing us.
Thank you. Have a good day.
Thank you. Bye-bye. We ready for our last case for the day?
Chief Judge Gregory, could we have a brief break before the next argument? I have
Absolutely.
a question.
You want 5 or 10 minutes?
Okay, thank you.
All right. Okay, thank you. Would you put us in the room, please?
This honorable court will take a brief recess. Judges, I'll move you to the
Ms. Lovey and Mr. Martinez, you can turn your video, and Ms. Lovey, you can turn your audio on.
Good morning, Your Honor. I'm not sure whether you wanted to start the argument or whether you wanted to address the motion first.
Yes, we want to address the motion first. And what we're trying to do, obviously, we want to be very careful as we must and not trespass on anything that we shouldn't talk about in public. But is it your motion, and the governor didn't take a position, but can we get into the substance of this argument without doing that? I mean, in other words, if we respect what's sealed, we have enough that can be spoken openly that could be enough to have this argument?
Well, it's sort of ironic because our position is we would prefer that the argument be open. My client and his family would like to listen to it. However, this is an extremely fact-intensive case about a corrupt ex-officer, and it involves evidence that I need to be able to discuss. So if the government and the court is okay with me discussing the evidence openly, I certainly have no objection to leaving this and would prefer to leave this argument open. But I do want to be free to be able to discuss the grand jury testimony, the FBI investigative reports. There's a lot of evidence, and this is a fact-intensive case.
Government, Mr. Martinez, what's your position on that? I mean, counsel did by the best she could. She said, my druthers is go open, but she's respecting the government's position. What is your position?
Your Honor, I'm confident that we can responsibly discuss what's in both the sealed and unsealed versions of the joint appendix on a public record. There were several references to sealed materials during oral argument before Judge Hollander below. So to that extent, I don't know exactly what Ms. Levy's going to say, but I expect that what we do have to say is a matter of public record in any event. All right. Well, is that fine with you, Ms. Levy?
As long as there's no restriction on my discussing the evidence, I'm perfectly happy leaving this open.
No, right, it's fine. And what we'll do, since everybody I think is being good faith trying to do this, Mr. Martinez, if at some point we do get into something that you didn't anticipate and now have a different view of it, I'll allow you to, to raise some question there, and then we might be able to look at that. But otherwise, I'm going to say you both have the range based on your representation of your position to argue the case as you would like and as your counsel leaving with. That's good enough? Is that fine? Mr. Martinez?
I appreciate that, Your Honor. Thank you.
All right. Okay, then. Thank you very much. It's pronounced, is it Lovey?
Yes, Lovey, Your Honor.
Yes. Ms. Lovey, you may proceed.
Thank you. May it please the court, I am Deborah Lovey from the Exoneration Project on behalf of the appellant, Keon Paler. The criminal charges that Mr. Paler pled guilty to were 100% reliant on allegations made by a convicted ex-Baltimore police detective, Daniel Herschel. Herschel's corruption ran deep, and his modus operandi was exactly what Mr. Paler has been alleging since long before his guilty plea, that the gun was a plant and that Mr. Paler was framed so that the officers could steal thousands of dollars from him. The government's position throughout Herschel's prosecution was that Herschel's misconduct began long before 2014, and that's how he amassed 1,700 discredited convictions. The government's position before the grand jury was that Mr. Paler was framed by Herschel, notwithstanding his guilty plea. And the government's position before the district court in the Rule 35 motion was that Mr. Paler's grand jury testimony provided the government with material assistance, that he had testified truthfully. The government's new position here, after the government vouched for Mr. Paler repeatedly and used him to secure the superseding indictment against Herschel, must be rejected. Herschel's rampant misconduct clearly predated Mr. Paler's guilty plea, and under United States v. Fisher, Mr. Paler should be allowed to vacate his guilty plea.
And what do you base your statement on, that Herschel's rampant misconduct clearly predated the guilty plea?
Sure. Well, there are a number of things that the court can look to. First of all, the first one is that Mr. Paler pled guilty in April of 2015, which is months after Herschel's first convicted offense, the Jimmy Griffin, which occurred in November of 2014. And then the government argued throughout the prosecution, numerous times that Herschel's misconduct had been years in the making, that it had, they specifically argued, because 2014 was significant in their case as well, that his misconduct predated 2014. Even Herschel's own lawyer talked about it spanning his entire career. These claims in the case are corroborated by counsel's letters in the discovery, by all the media reports cited in the brief, by the fact that Herschel's indictment was only 2 years after Mr. Paler's, and he had amassed 1,700 dirty convictions. And
it would be hard to imagine you could amass 1,700 bad convictions in a 2-year time span.
You would be hard pressed to do it, I believe. And that's why, you know, I'm happy to share with the court some of the things that the prosecutor had to say about it. The prosecutor made it pretty clear that they were looking pre-2014. If you looked at the record at JA 1718, the prosecutor talks about making the choice between criminal conduct and respect to the badge, and says that Daniel Herschel did that sometime prior to 2014. They talk at 1715 about how Herschel's conduct occurred before he joined the GTTF. He was robbing civilians with the previous unit he served with. So before he even got there for the GTTF. At 1732, it talks about him robbing people before he joined the GTTF. And there are numerous sites that are included throughout my brief. The government's position all along has been that this was rampant and long before. But obviously, if there's any question at all about the timing, then that just underscores the need for discovery and an evidentiary hearing. We don't think that
Ms. Lovey, you asked for discovery below. What kind of discovery would you be looking for?
Well, in the hearing below, only 4.5 of the IADs were disclosed, which was not enough to show the 1,700 convictions that have been compromised by Detective Herschel's involvement. If this court had any question about the timing of his corruption, we would be asking for all of the IADs involving Herschel's, whether they were sustained or unsustained. And that's why there was such a deficiency below, is because the court was only giving sustained convictions or sustained complaints. But we'd be asking for all of them with an opportunity to then, you know, set up the parade of people who were victimized by this clearly corrupt officer to show that this did predate Mr. Paler's guilty plea.
But in Mr. Paler's case, doesn't the interview of Mr. Harris corroborate what the officers said happened here?
Several responses, Your Honor. First of all, Mr. Harris this was an interview. This is not testimony, although the government likes to refer to it as testimony. This is just hearsay of an interview of what Mr. Harris supposedly said. But Mr. Harris was in a different part of the house. He was out of view of the stairs going up. He was with a small child. There were 4 officers. There was a lot going on. There was an arrest that happened. And Detective Herschel, in his proffer, in his own criminal proceedings, admitted that an officer went upstairs. So the fact that Mr. Harris didn't see an officer going upstairs, according to the hearsay report of this one government report, is not at all dispositive. Herschel's own admissions take you to at least an officer went up, and he originally
his mother would point to the fact that an officer went upstairs because she at some point said the clothes were lying everywhere.
Absolutely, and let us not forget these contemporaneous phone calls. I urge the court to listen to them. He, in phone call after phone call after phone call, was saying to his family, "These are dirty cops. They went upstairs. They took my money. This was a frame-up." He had nothing to gain by making these claims. It's preposterous to think that he was planning ahead years in advance for how this might somehow help him. And in fact, when the government tried to offer him something to gain, he was so afraid of former Detective Herschel that he declined. He chose to serve out the remainder of his sentence rather than take a reduction in his sentence because he was so terrified of these officers. So these phone calls have a real, they're very compelling. And he talks about...
I understand that here today you're arguing about all the bad conduct prior to the plea, but I understood, as I read your brief, I understood you to be arguing that the guilty plea would have been different if appellant had evidence of Herschel's misconduct in the years between 2014 and 2018.
No,
Am I reading that wrong?
Yes, and I apologize if the brief wasn't clear on that point. Before Mr. Paler pled, he had a strong hunch based on all the media reports and what defense counsels around the county knew that Herzl was a dirty cop, and he knew it from his own experience, but he couldn't prove it. And without the proof, without the evidence to show, he was forced to plead guilty, because that's how Herzl picks his victims. These were vulnerable people who would never be credited in a swearing match against a respected detective. Had he had this information before he pled guilty, he wouldn't have pled guilty. And that's what Fisher gives you. Fisher talks about there's this uncommon case where there's something so egregious that happened that we should allow the vacatur of a guilty plea because it was material to the decision to plead guilty. And you had defense counsel talking about, you had defense counsel's efforts to get the information on Herzl, his, affidavit, and Paler's accounts that they never would have pled if they could have gotten the evidence of Herzl's misconduct. Herzl certainly knew what his modus operandi was. That's imputed to the government. He knew he constantly had coordinated plans with the other officers. This is what he did. He framed suspects, he planted evidence, and he stole their money. And if Mr. Paler could have had that information, he never would have pled guilty. And that is what the case of Fisher is designed to address, that uncommon situation where you have something that really goes to the heart of the prosecution, as this one did. This would have been 404B evidence of modus operandi, of a coordinated plan, regardless of whether or not Herzl testified at trial. It would have gone to the heart of this case. And I think the real proof is, if this court were to allow Mr. Paler to vacate his plea, does anyone think for a second that the government's going to try and re-prosecute him? Of course not, given how dirty this cop was and how this fell into exactly what he was doing. And that's how we know this is evidence that goes to the absolute heart of the case. The government vouched for Mr. Paler in order to get the superseding indictment, and then they threw him under the bus. Judicial estoppel, all notions of fairness, United States v. Fisher, all of those support that Mr. Paler should be allowed to vacate his plea. If the court doesn't have any remaining questions, I'll save the rest of my time for rebuttal.
All right. Thank you, Ms. Lowy. Mr. Martinez?
Good morning, Your Honors, and may it please the court. Peter Martinez for the United States. Keon Paler is guilty. His guilty plea was knowing and voluntary. And serious as it was, the criminal misconduct by Daniel Herzl, who wouldn't have been a witness at Paler's trial, doesn't change that. I want to emphasize two facts right off the bat that dispose of Paler's claim under Fisher. First, the timing. The record shows that with one exception, every known instance of criminal misconduct by Herzl happened after Paler's guilty plea. The only exception.
Well, how do we know that? How do we know that? But if there wasn't an evidentiary hearing and the appellant was only given 4.5 of the complaints against Herzl?
Your Honor, all of the IAD material pertaining to all of the law enforcement officers in this case was provided to Judge Hollander prior to Mr. Paler's plea. At the time,
Judge Hollander. And do we have all of that in the record? Does appellant have all of that?
No, Your Honor.
Then I don't know how you can say that he had everything.
Judge Hollander, at the time she reviewed our in-camera submission, had a letter from defense counsel in which he laid out his theory of the case, Paler's allegations about what happened with respect to this arrest. There was also a discovery conference, a telephone conference, in which counsel laid out his theory and made his pitch to Judge Hollander as to why he should have been the one to review the files as opposed to her. Judge Hollander knew what the theory of the case was. She reviewed all of the ID material with respect to all 4 officers.
And she was conservative, or the district court was conservative in what the court turned over at that time out of concern for complaints not necessarily being sustained. Now, those 30 complaints may not have been sustained at that time, and for that reason, the district court was conservative. But now, 1,700 bad complaints later, perhaps those complaints are sustained. So I would like to understand from the government, the question the district court asked at that hearing was, how can appellant show conduct predating his case if you don't turn over anything as to what you have that might have predated his case?
Well, Your Honor, we can't go back and redo discovery now that there's a final guilty plea on the books. We did exactly what Paylor asked us to do in this
I guess
case.
we can now in an
Well,
evidentiary hearing, which is what they're asking for.
That is if we conclude that Fisher warrants relief here. And I would submit, in response to one of the concerns Your Honor just raised in terms of whether Judge Hollander was generous enough, it's not accurate to say that the only—
Not generous. She was being, the district court was being conservative, as the court itself expressed, and understandably so at that point. We're at a different time now.
I understand.
We
that,
know better now.
The factual point I'm trying to make is that the 4.5 IAD complaints she turned over, they weren't simply the universe of sustained materials. In fact, the complaint involving Mr. Griffin, which wound up being a substantive count in the racketeering indictment against Herschel, where the jury returned a guilty verdict, that was a pending complaint at the time. So that shows that Judge Hollander didn't limit the disclosures simply to sustained complaints. It shows that she took counsel's theory of the case into account and was sensitive to what the issues were going to be in the trial. Regardless, Your Honor, I would still submit that above and beyond the timing issue, we have the nexus to Paylor's case, and that's also required under Fisher. And the record shows that every known instance of criminal misconduct by Herschel happened in other cases, and that Mr. Paylor can't point to any evidence other than his own allegations that there was any misconduct in this.
Well, let me ask you this. In the government's view, was Mr. Paylor's testimony at his plea hearing the truth, or was his testimony at the grand jury that the government put on the truth?
Very much the former, Your Honor. And
so the government put on testimony in the grand jury that was not truthful?
Your Honor, Mr. Paylor testified in the grand jury immediately after meeting with the GTTF investigators for the first time. He was in Baltimore on a writ from his BOP facility, and my colleague interviewed him and put him in the grand jury on the same day.
Well,
it is
okay, so they can't both be true. Either what he testified to at the plea hearing, that was my gun, is at odds with what he testified to in the grand jury. That was not my gun. Which is the truth in the government's perspective?
His sworn admission of guilt is the truth. His grand jury testimony is false.
All right. So then the government did suborn perjury in the grand jury.
Your Honor, it's certainly true that we as prosecutors have an obligation not to knowingly suborn perjured testimony. It is also true that the grand jury is an investigative tool, and that we often put witnesses in the grand jury while we are still, and the grand jury is still vetting the reliability.
Well, I don't think you put witnesses in the grand jury knowing that he pled guilty, and the government knew that. So the government had to think that what he was saying in the grand jury was true, and what he said at the plea hearing was not true.
I'm not going to speak to the mental state of the prosecutor who put Paylor in the grand jury. I will.
What about the prosecutor or the government actors that then made a motion on his behalf indicating that it was true and helpful, his testimony in the grand jury?
Your Honor, that Rule 35 motion was made shortly after Paylor's grand jury testimony, before we had an opportunity to fully investigate what he was claiming. And we had an obligation to do that. We had an obligation to get to the truth, and we did. As you mentioned in Ms. Levy's argument, we interviewed Paylor's stepfather, Stuart Harris.
The government didn't feel an obligation to get to the truth before it put somebody in the grand jury under oath to say something completely opposed to what he had pled guilty to?
Your Honor, the investigators who put Paylor in the grand jury were doing that in the context of an ongoing investigation. They were using the grand jury.
Wait, you're saying an investigator put him in the grand jury. Was there not a prosecutor in the grand jury asking those questions?
Indeed, there was, Your Honor. It was an
okay.
And I would point out that the grand jury that heard Paylor's testimony didn't include his allegations in the superseding indictment against Herschel and two others. His allegations weren't mentioned at Herschel's trial or sentencing. He wasn't called to testify in either proceeding. And I was just explaining to the court that following his grand jury testimony, we interviewed Mr. Harris. Mr. Paler's counsel brought Stuart Harris to that interview. They were in the room for the interview. And during that interview, he eviscerated the testimony Mr. Paler gave before the grand jury. He said that the officers were in and out of the house. He said that he didn't see or hear anyone going upstairs and that he would have heard it from where he was standing in the kitchen. He said that nothing was out of place, including in Paler's bedroom when the officers left the house. He said that the police executed a house of the search warrant in 2010 and recovered 2 firearms then as well. He claimed he remembered that Paler admitted possessing those firearms. That's important. Mr. Paler testified.
Who is this that said all this?
This is Mr. Paler's own stepfather, the only civilian.
All right, what about his mother and Mr. Paler himself?
Mr. Paler's mother was not in the home for the arrest. There's no evidence of that in the record. I don't think that's a disputed fact. There is no evidence.
She was in the home immediately after and saw the clothes strewn about the bedroom floor and the money missing.
I don't believe that's true, Your Honor. I think that Mr.
You don't know. Maybe if we had an evidentiary hearing, we would know.
Well, there's no evidence of that. The stepfather was
right.
There were no other than a small child. The only individuals present for the arrest were the stepfather, the small child, and Mr. Paler. The mother was simply not there. So
does the government not share at least my concern that the government has talked out of both sides of its mouth on this case, a case that involves already a dirty cop? This just doesn't seem in the interest of justice.
Your Honor, I will come back to what I said a moment ago, and that is that at the time of Mr. Paler's grand jury testimony and at the time of the Rule 35, we hadn't had the opportunity to fully investigate what he was claiming, and we did that. I just went through the interview of Mr. Harris. The ATF interviewed Detective Romeo, who remembered seeing Paler with a gun and didn't remember anyone going upstairs. He hadn't been spoken with at the time of the grand jury testimony by Mr. Paler. And yes, the FBI interviewed Detective Herschel, who admitted to misconduct in other cases, but not in this one. And the suggestion that Herschel admitted misconduct is just, that's a distortion of the record. Both Judges Hollander and Berdar concluded below that there was no admission by Detective Herschel of officer misconduct at the scene. So, Your Honor, it is our office's position that knowing what we know now, if we had to do it over again, we wouldn't make the Rule 35. And that's because every piece of intrinsic evidence that's come to light following Paler's grand jury testimony supports his convictions, both in 2015 and in 2010. The evidence shows that he's guilty and that his testimony before the grand jury was false. And so I don't think it's unfair or that it's gamesmanship for the government to be defending his conviction in this appeal. To the contrary, what Mr. Paler is asking this court to do is to assume that the concrete hardened and froze immediately following his grand jury testimony at the Rule 35, and that any further investigation that undermines his claim can't be considered by this court. But of course it can. There's no dispute. Mr. Paler's lawyers were present when his own stepfather destroyed the credibility of the testimony he gave before the grand jury. So in that sense, knowing what we know—
How do you know his stepfather's credible?
Because he had no reason to lie. If anything,
How do you know?
Well, he is. Your Honor, there's no reason to believe that he wasn't telling the truth. I have no evidence impeaching his credibility.
Well, the government hasn't been the best judge of who's telling the truth in this case so far.
I think what the record in this case shows is that the government made great efforts to get to the truth. And that following Mr. Paler's grand jury testimony, we continued to kick rocks over to find out what happened. Had Mr. Harris's testimony gone the other way, had he come in—
What if the Rule 35 motion had gone through? What if Mr. Paler had not been so intimidated by the police that he accepted the Rule 35 motion? What if the Rule 35 motion had been granted? Then what would the government have done?
If the motion had gone through, Your Honor, we still would have done the investigation that we did to get to the bottom of what he was claiming. We still would have reached a determination based on the facts that the testimony he gave the grand jury.
After you already made the Rule 35 motion?
Yes, because we had an obligation
The motion that he was helpful and truthful before the grand jury wasn't, the facts weren't determined on that before the government made the motion?
Well,
What
I don't know that the Rule 35 would have
is
prevented
going
him from
on?
filing this motion to vacate. And once he filed the motion to vacate, and we realized that he had said what he said in the grand jury, and that there was a civilian witness who law enforcement had not talked to yet, we said, we better get to the truth of this. We better kick that rock over, whatever may be underneath it. And had Mr. Harris's interview gone the other way, and had he corroborated Mr. Paler's allegation, then Mr. Paler might have had a Fisher claim. We might have conceded relief, but that's not what happened. Mr. Harris didn't support Mr. Paler's account. He discredited it. So that is what I'm referring to, Your Honor, when I say that every piece of new intrinsic evidence that has come to light following Mr. Paler's grand jury testimony supports his conviction. And I want to circle back to a point I'd like the court to keep in mind. I want to talk about what this case is not about. We don't deny or minimize that Daniel Herschel committed serious crimes, but the case against Mr. Paler didn't depend on Herschel. Paler's guilty plea wasn't, as counsel has suggested, simply an acceptance of Herschel's version of events. By the time Paler entered his plea, we told defense counsel that we wouldn't be calling Herschel as a witness. And it was after that that Mr. Paler stipulated that had there been a trial in this case, the government would have proven beyond a reasonable doubt that he possessed a gun. And we'd have proven his guilt by calling 3 other officers, none of whom, despite Mr. Paler's attempts to muddy the waters on this, have been implicated in any wrongdoing. Our case might also have included extrinsic evidence that Mr. Paler possessed 2 guns at his house in 2010. We filed a motion to admit that evidence under Rule 404B, and it was pending at the time of the plea. So Mr. Paler knew and admitted in 2015 that Herschel was a sideshow, and that the government would have made its case beyond a reasonable doubt without him. The other thing I'd like to emphasize to the court is what Fisher actually says. In order to set aside his plea under Fisher, Mr. Paler has to show egregious police misconduct that predated his guilty plea and underpinned the charges against him. And we've talked about the timing issue, Your Honor, but I also want to talk about the underpinning or intrinsic misconduct requirement. And that's
Mr.
absolutely—
Martinez, Mr.
Yes,
Martinez,
Your Honor.
Here you're arguing that Mr. Paler is not entitled to this because we could have done all this without Herschel being involved at all. Well, if that's the case, why did you find it necessary to use him for the grand jury to get an indictment? You'd say based on that, there's nothing you know about him at all that would be really of any moment to his complicity in anything, right?
I'm sorry, I don't think I understand the court's
I'm
question.
asking you, why was it necessary to have him, since you said in terms of what he would have observed, what was it about that he said about Herschel was that important then about in this case? Was it what part of it? Because you said you wouldn't have called Herschel anyway. What part of it, what part of Herschel's involvement in this case would have been important that Paler could have testified or did testify?
Well, Herschel was part of the arrest team, and clearly we've known from the beginning of the case, way back in 2015, that Mr. Paler has been making allegations that Herschel engaged in misconduct. But
what was the misconduct that day?
On the date of Mr. Paler's arrest, Your Honor?
Yes. What was the misconduct?
Mr. Paler has alleged, contrary to his sworn statements during the guilty plea, that another detective stole money and that the firearm the officers recovered from the seat cushion on his front porch was not his.
You evade my question. I'm saying, what is Herschel's involvement individually? What did he do?
What did he do with respect to Mr. Paler's arrest?
Yeah, that was wrongdoing.
There was no wrongdoing by Herschel in this case. That is our position.
Oh, so at the grand jury, he testified to no wrongdoing on Herschel's part at all.
Mr. Paler's grand jury transcript is certainly not a model of clarity. He claimed in the transcript that another officer went upstairs and stole money. That much is clear.
He said nothing about Herschel at all. That's what you represent to the court?
made claims about Herschel arresting him in other cases, and he said that Herschel was among the group of officers who arrested him in this case. He did not allege that Herschel stole his money. He didn't allege that any particular officer planted the firearm. I don't think he even alleged, I don't think you can read the transcript to suggest that he alleged that the firearm was planted. He simply claimed it wasn't his.
All right.
But before Your Honor's question, I was talking about Fisher's requirement that the misconduct underpin this case. And I don't think you can read that requirement out of the Fisher opinion. Whatever word you use, whether it's underpinning, intrinsic, or some other term, it is clear that what drove the analysis in Fisher was that the misconduct happened, the law enforcement misconduct happened in connection with the defendant's case. And in that case, a task force officer provided a search warrant affidavit for the defendant's residence, which led to the discovery of the only evidence against the defendant in this case. In that case, we've cited a long list of cases at pages 38 and 39 of our brief in which district courts throughout this circuit have limited to Fisher to misconduct in the defendant's underlying case. Your Honor, Mr. Paler cannot satisfy that underpinning requirement. He can't point to any intrinsic evidence of officer misconduct other than his own allegations, which he's of course been aware of all along. During her argument, Ms. Lovey tried to manufacture an allegation of extrinsic misconduct by claiming that Herschel admitted that another officer went upstairs and stole money. Judges Berdar and Hollander both considered that argument below and concluded that it's wrong. There's only one interview during which Herschel talked about Mr. Paler's arrest. The 302 of that interview is at page 1423 of the joint appendix. And it's clear from that 302, Herschel said he never saw Sergeant Burns stealing money, never suspected him of stealing money.
I don't know why we should believe anything Herschel says at all at this point.
Well, Your Honor.
Why are you relying on Herschel for anything?
Ms. Lovey's relying on him as having admitted something, and the 302 memorializing that interview flatly contradicts that.
Right, I'm sure there were 302s in and reports in the 1,700 other cases that he engaged in misconduct in. I just don't understand why the government would rely on him for anything at this point.
We are relying on the fact that the
or vouch for him.
It's not vouching for former Detective Herschel to say that the 302 by an FBI agent memorializing his interview accurately reflects what was said. That's the point I'm making to the court.
All right, that's fair.
And so Mr. Paler, the fact remains that he can't come up with any new intrinsic evidence of misconduct in this case other than his own allegations. And for that reason, his claim under Fisher fails. And so for all the reasons I've mentioned this morning, we'd ask the court to affirm Judge Hollander's ruling denying the 2255 in this case.
Thank you, Mr. Martinez. Ms. Lovey.
Thank you. Briefly, Your Honors, the government cannot escape. This case is absolutely dependent on Herschel, and the efforts to run away from Herschel here should be disregarded. I just want to remind the court to take a look at the cites in the government statement of facts. The only thing they are relying on to accuse Mr. Paler of anything is Herschel's probable cause affidavit, to Herschel's police reports, the plea agreement drafted by Herschel, or based on what Herschel said. The only other officers who have gone on record are Burns, who did not see a gun, Romeo, who contradicted what Herschel said, and we've never heard anything from Moore. So this case, whether or not Herschel testifies, is reliant on Herschel. This would be 404B evidence.
Is Herschel the only one that did a report, correct?
Yes, he is the only one who did a report. This case is absolutely his. It hangs on him. The second thing I'd like to talk about briefly is that this court has been very interested about evidentiary hearing, and counsel for the government keeps disputing the evidence. I want to remind the court that if this court is considering an evidentiary hearing, that unless the motion and the files and records of the case conclusively show that he's not entitled to relief, an evidentiary hearing was required. And that the facts have to be viewed in the light most favorable to the 2255 movement for that adjudication. So if there are remaining questions about the IADs or anything else, there should have been an evidentiary hearing. With that said, the government's reliance or misconstruction of the evidence, I would dispute highly. Mr. Harris does not undermine Mr. Paler's withdrawal of his plea. He was clear that the officers were in for 10 minutes, which is certainly more than enough time. And Herzl's proffer did admit that an officer went upstairs. It didn't just admit that an officer stole money, but it admitted that an officer went upstairs, which contradicts his police reports, which is not mentioned in his police reports, and certainly given all of the modus operandi evidence of him working in coordinated plans to do this is sufficient here. Lastly, I just point out that the IADs that the district court gave Mr. Paler were woefully insufficient. The court only looked at 30. The court admitted that it looked at those before it had any knowledge about what a corrupt officer they were dealing with, and it only considered sustained reports. Even the district court sounded remorseful about how limited the discovery was in this case. We would ask that Mr. Paler be allowed to vacate his plea, and at a bare minimum, if the court isn't ready to do that, that he be granted discovery and an evidentiary hearing. Thank you.
Thank you, Ms. Lovey and Martinez. We would love to come down and greet you in our normal tradition, but we cannot do that. But know that we very much appreciate your arguments in the case, and we hope that you will be safe and continue to be well. Thank you so much. With that, I'll ask the deputy clerk to adjourn the court until this afternoon.
Thank you.
The honorable court stands adjourned until this afternoon. God save the United States and this honorable court.